to get ready for our guest speaker.
Ready, huh?
Mike Jansen. What's the name of your firm? Is it still?
The law firm that I belong to, that I'm a partner in, is Timmons, Owen, Jansen Tichy, and we have offices at 1401 21st Street, Suite 400, Sacramento, California. We're in the process of closing down the Woodland office. I'm going to have other office space someplace else in Woodland that I'm trying to negotiate now. I'm talking to Andy and just looking around. The Sacramento practice, and the case I'm going to talk about today is the first case that I got in Sacramento that arose right here in Woodland. But it ended up going to Sacramento because most of the bigger cases, people more seriously injured, surprisingly, they think that if you are in this small town, then you probably can't handle a big case. And so the guy went to Sacramento, and it came referred into me around the corner. So I was going to talk about the Troy and Atlanta PAC Act, and that's the MICRA Act, the Medical Malpractice initiative that's going to be on the ballot. I just talked about that 2 months ago, and so I thought you'd probably not be too happy if I did it again. That's Proposition 46 on the ballot in November, and that's the initiative that requires doctors to drug test and then also takes the lid off of the MICRA cap for damages up to a cost of living increase from 1978. That's all it does. So you've already heard all about that. So I'll go on and talk about a thumb. And that's what this case is all about. And think about your thumb. How much is your thumb worth? Writing? Picking up utensils? And in the case of Eric, my client, Eric has small children, and just taking the diaper adhesive to be able to put a diaper on, Crystal can attest to this.
Actually, I cut my finger and I couldn't change your diaper.
Yeah, how do you take that thing apart with your fingers like that with no thumb? So Eric is an auto mechanic, and Eric has a van full of tools, and he just drives around and people hire him to fix their trucks and their cars and other things. And he has a friend by the name of Salvador Orozco. Orozco lives in Oakland, but he owns a tract of land out here by the Wild Wings, and it's just bare land, and it has a well on it. Salvador Orozco decided that he wanted to pull the casing out of the well because it was aluminum, and he wanted to sell the aluminum. That's the kind of guy Salvador is. If he can make a buck on anything, that's what he's going to do. So he called Eric, his auto mechanic, and said, "Eric, come and help me pull this well casing." And so Eric showed up after he had worked on a car down in the Bay Area, and Eric lives up by Nevada City. And so on his way back home, he stopped off at Orozco's place by Wild Wings, and there's this little pump house. It's about a 10 by 12 shed, and the well is inside the shed. And it's an old building that probably was built 50 years ago, and I don't think they've painted it since. And so Orozco had made up this contraption. It was 1.5-inch angle iron that was about 4 feet long. And he then took a cable and wrapped the cable around it in a figure-8 type of thing, and they would grab the pipe and they would pick up this angle iron, and there's a couple hundred feet of aluminum down in the well. They would pick up this angle iron and put it on the side 2x4s of the shed, and then they had another angle iron with another piece of cable, and they would tie that around the base, and then they would pick that one up, and then they would just do that and keep doing that until they pulled the pipe up out of the ground. This was Orozco's plan. And so Orozco cut a hole in the roof of the shed so that they could stick the pipe out, because they didn't have any means to cut the pipe. They were pulling a couple hundred feet of aluminum pipe out of the ground. So Orozco had this whole thing set up, and Eric shows up. It's very late at night, and he just says, "Okay, let's just get this thing, you got this all set up, let's get it." And so they started picking it up. And Eric is a strong guy, so his job was to pick it up, and so he got a piece of it, and they pulled a couple pieces of 20-foot length of pipe out of the ground, and they were sticking out the roof of the shed when all of a sudden the 2x4, or the angle iron, slipped off of the 2x4 and Eric is standing there holding the angle iron in his hands, and the pipe went down, the other piece of angle iron came down, and it's called an avulsion amputation, where it crushed and severed his thumb at the same time. So, of course, there was also, one of the things, he felt that, but one of the bigger things that caused him concern was there was blood all over the place, and he couldn't figure out where the blood was coming from. The cable, when the cable went by, it took a half an inch across his chest. It ripped his shirt off him, and he was squirting blood all over the place. And so they were trying to cover up the blood and grab the rest of his shirt and tried to stop the bleeding. And then he realized, I got a bigger problem here. So they finally grabbed the thumb and they rushed him to Woodland Memorial Hospital. And Woodland Memorial Hospital took one look at the thumb and one look at Eric, and said, they turned white and just said, we can't handle this.
Oh my God.
And so he had to be taken then to, he got lucky, and they called around to a couple hospitals. And the California Pacific Medical Center in San Francisco actually had a guy named Andrew Watt, who's one of the world's foremost authorities on severed appendages. And they got lucky, and he was on call, and so they shipped him down to CPMC. And Crystal's already seen the picture.
I saw it.
We took him to we took the pictures to F&F. But
Yeah, no warning.
so they reattached the thumb, and Andrew Watt did a terrific job of doing that. And but he was still hospitalized for 3 or 4 days, and so they kept him hospitalized so that they could try to make sure that the blood supply and the nerves would regenerate. And it turned out after about 4 days, it was clear that the thumb wasn't going to make it. So they had to amputate the thumb. And they tried to leave as much of his thumb as they could, but they ended up having to amputate it off. And then they sent him home. He had about $125,000 in medical bills from CPMC, and when you consider what they did, 2 major surgeries and the emergency and one of the world's foremost experts, $125,000 was pretty much a pretty low price. Now, the part that is interesting, at least to an attorney who handles a case like this, Eric, being an auto mechanic kind of guy and kind of works out of the back of his truck, he really didn't have a lot of health insurance. In fact, he had no health insurance. And so when it came time to pay the bill, they had to apply for Medi-Cal. So Medi-Cal, and this is after the fact, when people are hurt and they don't have insurance, then the hospital, UC Davis Medical Center does it all the time, they'll apply for Medi-Cal so that then the hospital can get something. Well, CPMC was paid $5,000 for the reattachment and then the amputation. And so that's Medi-Cal. That means the taxpayers in the state of California paid $5,000 for Eric's health care. When we get it as a third-party case, we have to reimburse Medi-Cal. So we happily reimburse them their $5,000. But that's something that the Affordable Care Act and healthcare has got to change. When you have $125,000 in bills and Medi-Cal only reimburses $5,000 of that, there's a problem there. But at any rate, so Eric is he's an auto mechanic with 2 little kids and no thumb. So a friend of his referred him to an attorney, and the attorney was in Yuba City, and he's an attorney who does a lot of personal injury cases, but the guy never tries a case. He's never tried a case in his life. And so he took one look at the case and he said, well, this is a work comp case. Anyway, it's not even a third-party case. And so he referred the case to my firm in Sacramento, and that's how we ended up getting the case in Sacramento, rather than it happening right here in Wild Wings. Why didn't I get the case here in Woodland? I didn't. So at any rate, the attorney in Yuba City, who's a third party, does personal injury practice similar to mine, except I try cases. He referred the case down to our firm as a work comp case. One of our work comp attorneys took a look at the case, and he says, if I'm off with an uninsured employer, so no workers' comp insurance on the part of Orozco, who owned the property. Of course, he just was out there trying to grab some pipe. With no workers' comp insurance, it's a $3,000 case that isn't even worth the amount of effort. And that's our work comp system. And so the work comp attorney in our office actually said, this is a case, you got a work comp case, but it's more work, more trouble than it's worth. You're not going to get any money. It's not worth it as a work comp case. One of the things that we do with all cases that come in, if we reject a case on the work comp side, one of the third-party attorneys, like myself, takes a look at it. The other third-party attorney thought, well, there might be something here, but he wasn't really sure if there was a case there or not. And so he said, have the guy come in and talk to Mike, and we'll see what we can do. So I think there's a third-party case. It's clearly a third-party case, and there's no problem with it. The guy created this contraption. He was negligent in the design of the contraption. He was negligent in the carrying out of it, and the way he set this thing up. Now, and Eric maybe shouldn't have participated in it, but he didn't create the monster, and he didn't drop the thing, and didn't allow his thumb to be severed. He was just standing there. So I felt that there clearly was a case. So we submitted, put all the medical records bills together, submitted a demand to Orozco's insurance company, and I demanded their policy limits. And I had no idea what his policy limits were. Most homeowners have $100,000, and if you have $100,000, go see Carmen, because that's not enough. And so he had, luckily, because he owned some properties down in Oakland, he had $300,000. And so I demanded the policy limits, and this incident happened on May 4th of 2013. And by Christmas of 2013, we had him for $300,000. So that was a happy ending. Took care of the Medi-Cal lien, because that's statutory, you gotta do that, and put a chunk of money in his pocket. Now Eric is not the most responsible and not the most articulate and I guess financially wise guy in the world. So I also hooked him up with a financial planner in Sacramento, close to where he lives, so that he could do something with that money so that his kids wouldn't have to worry about having a roof over their head for the rest of their lives. So, and I got nothing for that. I didn't want any interest in that, and that's just one of the things that we do. Stephen?
So, if he didn't have a homeowner's insurance policy, it would have been a good case for you, right?
Right. Although Orozco, he owns some properties, and I haven't done an asset search on him, per se. I have had cases where the people have serious injuries, and if there's no insurance, I do an asset search on the defendant to determine if they have anything. The problem with that is that even if you determine that they have something, people will set up trusts, or they'll sell the property to family members, and you can unwind all that stuff, but it's a lot of time and effort, and a lot of times the courts aren't real sympathetic to you trying to unwind somebody's business transaction or their personal transaction.
So this case was kind of a fairly easy case for you then?
Well, it was.
It
was an easy case, although it had to be identified. The first personal injury attorney missed it completely.
Yeah.
It's not a work comp case because it's just too much trouble and not enough. The second third-party attorney thought maybe, but it wasn't his cup of tea. And I just said, no, this is a good case. I know we can do this. And so it depends a lot on who looks at the case.
So did you have to go to trial, or you just settled?
They paid us the policy limit, and when you get a policy limit, there's no other money in the case. You're never going to see any more money. And so to pursue a case beyond the policy limit, then the insurance company says, okay, we're going to take our policy back now. And they do have a duty. Insurance companies have a double duty. They have a duty to defend you, and they have a duty to indemnify you. So once you bring a claim, if I were to bring a claim against you, they would say, okay, here's the policy limit, and if you don't accept it, then we have a duty to defend, And I've had defense attorneys tell me they love those cases. They've already offered the policy, and the defense attorneys love those cases because they just build their brains out. They just cost all sorts of money. It's a long time thing that happens in the courts, and they take depositions, and the defense attorneys just make all sorts of money on that. Yeah.
Did the medical center have any sort of lien on a settlement, or was the $5,000 paid in full?
That was paid in full, and they did not assert a lien. Now, this is something that happens. There's a case, Howell versus Hamilton Meats, that I've talked to you all about, that came down 2 years ago, that is really a stupid decision by the California Supreme Court that says the measure of your the measure of your claim in a personal injury case is what an insurance company pays for your medical care. And so, in other words, the insurance companies are dictating how much you can claim in your personal injury case. And that's ridiculous, but that's the Supreme Court decision. And so what the Sacramento hospitals are doing, and many other places, the patient goes in and gets the medical care, and the insurance company pays for that medical care, and they have a contract with the insurance company and the hospital to pay a certain amount. And usually that's 40 cents on the dollar. And then after the hospital collects that money, the hospital will then assert the remainder as a lien under Civil Code Section 3045. It's called a hospital lien, and it has teeth in that the hospital can sue the insurance company, and they can sue the attorney if they're not paid on that 3045 lien. Now, I think that 3045 lien violates state law. There's a Welfare and Institutions Code section that says they can't do that. They do it anyway, and they say, okay, so sue us. And if you have a big enough case that warrants that litigation, okay. But most cases aren't that big to warrant taking on UC Davis Medical Center or Sutter Health or any of these other hospitals.
If they had done a lien with them, they could have been entitled to more if they didn't take the Medi-Cal portion of it, and then there was a settlement, right?
Once they accept Medi-Cal,
They shouldn't have done the Medi-Cal though, if it became a case kind of thing, right?
Well, and it used to be, a couple of years ago, a hospital could accept Medi-Cal, and then if they found out that there was insurance out there, they could kick back the Medi-Cal money, and then they could go after the insurance money. And that was a real abuse. Patients didn't know which way it was going. And so the legislature actually took that law away. And so the hospitals, once they accept that Medi-Cal, they're stuck with the Medi-Cal. What the hospitals are saying, which is totally disingenuous, they're lying. They say, well, the insurance company paid us for only certain services, and we provided all these other services that we weren't compensated for. And that's, if there was no third-party case, they wouldn't be looking for any other money. Why are they looking for, they're only looking for money because there's a third-party case. The lien you're thinking about is a lien where the patient agrees that out of their recovery, the attorney will pay the medical provider money. That's a lien agreement that you enter into with your patient and the attorney. A 3045 lien is implied by law, and so nobody has to sign any papers. It's just the hospital sends out a lien, a notice saying, you owe us this money. And the only way you can stop them is do a declaratory relief action, sue them in court to try to get a judge to say, no, you don't have a lien.
When you are, you win the case and you get the money and you disperse it. So is it the attorney's responsibility to disperse the money out? It's like an escrow account, and it's not like the plaintiff or the...
Right, and that's one of the services that we provide, because there's no way, there are many attorneys who don't keep up with lien law and who practice in personal injury. And that's one of the things that I pride myself on, is having the latest ideas and the latest thing on liens to try to maximize the recovery for my client. You know, to have you handle your lien with the hospital, you don't have a chance.
Right.
You know, and at least I can negotiate with them and I can threaten them, and hopefully act in your best interest. If you are my client, it's your case. You make the decision, but we have to make that based on what's in your best interest. What's going to maximize your recovery. So the hospitals and the insurance companies are making a 30% profit. 30% profit on the money that comes into them in health insurance. Now your grocery store you know, grocery stores make 3 at the most. I heard 1. So it's between 1 and 3% profit on groceries. So they say, well, why can't insurance companies make profits? Health insurance companies make profits. Well, sure, they should be able to make profits. Why not like groceries? You know, it's just like health and groceries. Well, they're not. They make 30% profit. So that's just one of those arguments. I'm happy to answer any other questions. All right, thank you.
Thank you.